Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. The presenter of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hi, it's Andrew Struve from the Buchalter firm, discussing with us all today taking and defending remote depositions, practical advice and pitfall avoidance. And so we are in an age of a so-called new normal, and COVID created the need, but then we discovered the benefits, and the benefits actually are quite outstanding if we know how to use them. And so what I'm trying to frame for you all today is how to get the most value out of this new paradigm of these remote depositions. So, as the slide will indicate, all states in the federal court systems permit remote depositions at this time. They were forced upon us because of the COVID pandemic. But what has come out of it is new efficiencies and new ways to represent our clients better and to practice law more efficiently. And so we're adapting to that. And so the slide will show you that in a survey taken, and I won't attribute it to the survey taker, 83% of practitioners have reported that they will continue to do remote depositions even post-pandemic. There's a lot of benefits, time. You know, we've all flown across the country to take a deposition. Fly to New York from LA, and you spend a night in a hotel, you take the deposition, you fly back. Well, we don't really have to do that anymore. So there's an avoidance of cost, there's an avoidance of needless travel, and a lot of it goes into work-life balance. We've found that time spent on airplanes are not as useful as time spent at home. And so this is a way that we can transition to a more efficient, more productive environment. But, like the slide will say, new techniques and strategies are needed. And we're still all learning through the best practices of how to do this. And so what I'm going to attempt to give today is just a thumbnail sketch of what we've learned so far. And there will be refinements on this. There will doubtless be refinements to rules. But the paradigm will remain the same in my view. And so we have to adapt to it. And the trick is to find the benefit for the client, of course, and for the lawyer, of course, and for the judicial system, of course. And so that's what we're trying to do. So the slide will indicate many states have procedural rules addressing how to deal with video depositions. And they're not all uniform. They vary in a number of respects. But the protocols and the cautions that one state or another may put into them I would recommend are translatable to other jurisdictions so that we can all learn from them and model them, even if our particular jurisdiction does not have that particular protocol or paradigm, right? So the slide will say attorneys who are fully versed in the laws applicable to remote depositions will be in the best position to an effective, productive, and admissible deposition, or if defending, to protect their witness, right? So we've all done, most of us have done, in-person depositions, some of us for many years. And we're used to our methods of witness preparation. We're used to our methods of working with our witness or working with an opposing witness during deposition. Video makes it a little different. The ground rules still apply. So what I would say is preparation certainly still applies. Knowledge of the facts certainly still applies. If you're defending, bonding with your witness still applies. If you're taking the deposition, knowledge of the deponent still applies. And so that hasn't changed. What has changed is how do you do it remotely, right? And that's what I'm going to try to give you a little bit on today. So I'll do a quick run through of the rules. Obviously, we're multi-jurisdictional, and although one rule or another might not apply to the jurisdiction in which you practice, you can take learnings from each of them because I think they're translatable to other jurisdictions, and you can file them away as best practices, if that makes sense. So I turn first to the state of New York, the Commercial Division amended Rule 37. It took effect on December 15th of 2021. It applies to commercial cases, but that's really what you get in the larger cases. And it says the court may, upon a showing of good cause, order a deposition to be taken remotely. Well, in these times of COVID, it's almost automatic. The deposition will be taken remotely. But the factors relevant under New York Rule 37 are significant. What they consider as good cause, the safety of the parties and the witness, including whether they and counsel can safely convene in a single location. It says, which shall be given priority over all other considerations. So that's a strong statement, given priority over all other considerations. And then it talks about the distances involved and the cost of travel and likeliness of the witness's importance to the case and those kind of things. But the common idea of the COVID rules is to protect the witnesses and the persons. And I'll hearken back to my peroration in the beginning, which is there's a lot of benefit to these remote depots if you know how to do them, right? And so it's just a best practices question at this point. So then there's a protocol that New York put in place. And the reason I put New York up front was not by any geographical preference. They do a great job at many things. But the reason I put it in place was I thought the protocols were particularly useful because they emphasize some factors that I think other jurisdictions would also consider and hearken to for what that's worth. So I'll just recite them. All participants must be clearly visible. Their statements must be audible, and each should use best efforts to eliminate noise and distraction. Next protocol. Counsel shall not communicate privately with the deponent during the deposition through electronic means. End quote. We'll touch on that more in a bit. Next, if counsel needs to consult with the witness to determine whether privilege should be asserted, he or she may do so only after the witness states on the record that he or she needs to consult with counsel for that purpose. These are rules of fairness. And they're attempting to embody what we've always done in-person depositions and trying to replicate that to the extent possible. And I hear horror stories, and we'll talk about cheating later, about deponents and lawyers texting each other and stuff during a depo. No, that's not what we do. You got to play by Hoyle's rules, right? And that's what the court expects. That's what all counsel expects. And that's what this protocol from New York attempts to embody. And then the last one is the parties shall specify a protocol for sharing and viewing of exhibits. And we'll turn to that too. So one of the reasons I started with New York is the amended Rule 37 from December of 2021 contains a statement that I haven't seen in any of the other states that I've visited, but it seems like a very fair rule, very fair rule. And it says, and I quote, "An attorney's failure as a result of technical difficulties to make objections or give instructions not to answer shall not be deemed a waiver as long as remedied as soon as practicable." End quote. So the point of the matter is, if technology fails, if you get stutters and blips on the internet, as you always shall, what this protocol in New York Commercial Rule 37 envisions is, we'll make it up to you. We'll give you a chance to put the objection in where it should have been. And I think that's a very appropriate thing. And no matter what jurisdiction you're in, I think a judge would give you the same kind of break and leniency, certainly hopefully. But I point that out to you, if you run into that practicing in whatever the other 49 states you're in, you can hearken back to that New York 37 rule. So, turning to the federal level, FRCP 30 allows parties to conduct remote depositions by stipulation or court order. FRCP 30 to date has not been amended. I suspect it may be, but the point of the matter is, on the federal court jurisdiction, I would not look solely to Federal Rule 30 because almost every district court that I've encountered and almost every local judge's standing orders that I've encountered permit remote depositions by order of the court. So if you're in federal court, my advice would be to hew very carefully to the rules of whatever district you are in and to the standing orders of that district and to the standing orders of the judge upon whom you're appearing. And that'll bring you a lot of clarity. And I think the courts will be very helpful with that. So I would not be totally beholden to the federal rules as they're currently written. Now, having said that, there are some things in FRCP 30, Federal Rule of Civil Procedure 30, that we need to be mindful of, okay? And this, frankly, applies to people in any jurisdiction. And like I said, this particular rule might not be binding in the state court of wherever you happen to be, but these are good practices that one should consider. And so I offer them for your consideration. One of the FRCP 30 rules is, it requires, this is FRCP 30 B5B, for those of you who like citations, requires that non-stenographic recordings not distort the appearance or demeanor of the witness or counsel, which could occur if the quality of the video conference or recording method is low. So, take a step back for a second. Don't manipulate or mess with the video, right? Just try to have an honest recording of the video. There have been times in my life when somebody wishes to intimidate a witness, they'll bring in a video recording camera. Now, these days, you can record anything off of an iPhone, but they'll bring in a camera that looks like it came off of ESPN Sports Center, right? Just a big hulking mailbox there. No point in that. That's kind of Bush League. But just deliver a fair video. That's all they're saying. And I think that just about any court would agree with that. Next one, also under FRCP 30, parties should take steps to ensure reasonable levels of quality. End quote. Comma, yes. You want a quality record, right? For good or for bad, you want a quality record. Pretty easy. Now, FRCP 30C1 says that the court reporter has to directly supervise the recording. Well, that's been construed in the past as requiring the reporter to be present at the deposition with the witness and with the videographer. Rule hasn't been modified to date, but again, I think your local rules or your judge's standing orders will clear that. But it is on the court reporter to make sure that a clear and accurate record is made. So now I'll turn to California, where I practice. And Code of Civil Procedure, and the title will be on the slide, 2025.310. It says at the election of the deponent or the deposing party, the deposition officer may attend the deposition at a different location than the deponent via remote means. And the deponent is not required to be physically present with the court reporter. That's important because in pre-COVID times, the court reporter was required to be present. That's all been amended in 2021, and that no longer applies. And then what's equally important is, also as amended in 2025.310B, any party or attorney of record may, but is not required, to be physically present at the location of the deponent, end quote. So this becomes kind of interesting. The COVID times are very medically, politically, and emotionally charged. And there is an argument that a deposition or any testimony is more meaningful if you're actually physically present with the person. I would encourage practitioners to work with all counsel to arrive at stipulations that mitigate those kind of arguments. And I would advise all practitioners to be respectful of other people's feelings and medical concerns and to work together, because that's baked into all of our state ethics codes. It's also kind of a fundamental rule of decency. And this is not a time, in my personal opinion, to attempt to exert a litigation advantage based upon people's medical fears. So that's just, again, as I said, one person's opinion, just one lawyer's opinion. All right. So, California rules, once again, you have to serve notice. Well, that's obvious. This is interesting. The amended rule 3.1010A says the party that makes all arrangements for any party to participate in the deposition must do so in an equivalent manner. So you don't disadvantage, end quote. You don't disadvantage the other side. But it says each party so appearing must pay all expenses incurred by it, and I would add her or him, or properly allocated to it, her or him. So in other words, if the court reporting service charges fees per attendee, well, that's on them. But as the deposing party, you have to make an effort to ensure the other people can participate on an equal and equivalent basis. Again, it's just fundamental fairness. The rule goes on to provide that any party or attorney may be physically present at the location, and I'm paraphrasing now, if you give written notice of your intention to do so at least 5 days before. So you want to pay attention to the notice of deposition that you serve. And again, I will fall back on my prior suggestion that even if one or the other jurisdictions doesn't have this particular rule, protocol, what have you in place, if you kind of mesh them all together, you really can't go wrong. Hopefully can't go wrong. So I would encourage you, even if you're in California, to look at the standards of New York. If you're in North Dakota, to look at any of the standards. And so we all work together. Does that make sense? All right. And so the next slide is pretty easy to deal with. But the point of the matter is that people who wish to appear and attend, it comes down to fee sharing on your bigger cases, your MDL cases, your key tam cases, those kind of things. You may have 100 lawyers. Paraphrasing this California 3.1010B is you share the costs. It's only fair. So that's what that says. Now, what I've attempted to do in the next series of slides is to create an amalgam of American Bar Association recommendations and also those of numerous state bars. I have, in preparation to spend my time with you today. So what we have is the amalgam of what I put together of the American Bar Association and various state bars recommendations as to protocols for remote depositions. And so here's the amalgam. There should be agreed upon between all counsel before any deposition starts on these topics. The video platform to be used, right? You have to have an agreement as to what you're doing. Now, it's usually not that hard, in my experience, to get an agreement on that. But you want to make sure everybody's on board. You'll have to decide tactically, will it be a mother may I, or you just say it's going to be a Zoom or a WebEx. Strategically, the latter might be a better way to go, but I offer that to you for your consideration. You absolutely want to make sure you have a high-quality webcam and mic for the witness. That, without that, you have no deposition. A guarantee that all counsel will familiarize themselves with the technology and ensure they can properly be seen and heard. This is very important. There's a lot of folks who parachute into a deposition and say, "This is Mr. Bloke, but I can't hear you, and my mic doesn't work, and I'm sweaty, and it's too cold in here." No, you want to work that out ahead of time. You can actually publish a protocol if you're on a large case and say, "This is what we're going to do." So I would encourage you to do that ahead of time. It makes for a much cleaner proceeding. Next is the method by which you'll mark and identify exhibits. I'm going to go into that in more detail in a little bit. It's colossally important, and it's one of the bigger challenges that video and remote depositions pose. Compliance with confidentiality requirements under protective orders and court orders. Make sure that you get an agreement, if I might humbly suggest, with opposing counsel, especially if you have, shall we say, a rather oppositional opposing counsel as to how we're going to deal with the protective orders, sealing of exhibits, and that kind of thing. Because otherwise, if you're on the other side of that, they can torture you with that. Been there, done that, have that t-shirt. So think about that in advance, okay? Now, there is this provision in a number of jurisdictions that allow for a hybrid deposition. And you should consider that. Defending, if it was a really big case, I would be in person with my witness, sitting right next to her. But I also would not have the ability or the inclination to compel other counsel to come join in that conference room, again, in this time of COVID or even beyond that, right? And so you can have a mix. You can have a hybrid between both. The trick is adaptability, and you want to be in these situations, if I might respectfully suggest, the epitome of reasonableness, right? That's, you'll never look bad to the court if you're the epitome of reasonableness. All right, so then we turn to the special challenges that these remote depositions pose. And I started off, not by accident, with the topic of comparative informality. See, when everybody's gathered around a big conference table in some fancy lawyer's office, with $18 an hour parking and all those kind of things, and office tower, and it's also very formal, and you got the court reporter sitting there, and everybody's wearing a tie. Well, that tends to get the witness's attention, especially if they're a layperson. The trouble is, when you're doing it remotely, you have the problem of what I call comparative informality. And it's been compounded by the fact that over the last years, with people working remotely, they've gotten used to attending Zoom meetings and those kind of things from home. They've gotten used to sweatpants, and their head kind of lolls around and that kind of thing. That really doesn't work well in a deposition, right? So you have to kind of shake them out of it a little bit. And one of the admonitions that's often given is, testimony you'll give today is just like you're giving in a court of law. Well, that just sounds kind of, somewhat rote. But the point of the matter is, in the comparatively unlikely event the case goes to trial, that deposition will be shown in a court of law. And so if somebody is leaning back in their chair, lounging in their sweatpants, yuck. It doesn't look good. The jurors will have been dragged into court against their will for the proceeding. And then they got a video of you in your home, in your sweatpants, petting your cat. It just doesn't go that well. So I think that's something that needs to be observed upon. I also think that the comparative informality of the video setting is compounded by the fact of all the Zooms and WebExes that we've had over the years. And that people feel more relaxed. Well, if you're defending the deposition, that's a real bad weapon, because the last thing you want is for your witness to feel more relaxed, more informal, more casual. They'll tend to ramble. They'll volunteer information. They have to be, when you prepare them, they have to be straight, focused, and serious. Answer the question, and nothing but that question. Don't volunteer. Deliver the answer, be straight, truthful, and that's it. Okay, and they need to understand that. So I recommend that to you in terms of your preparation of these witnesses. The next topic that I mentioned is shortness of attention span. And the lack of formality compounds this, because if you're in the deposition room, conference room, fancy law firm, $18 an hour parking, etc., the solemnity of the situation is kind of ingrained in you, right? But if you're in your own home, God forbid, when you're doing the deposition, your attention span may be somewhat less than if you're really on the hot seat in person. And so as the party, and by the way, this plays either way. This is not just about defending a deposition. It's also about taking one. Because if you're taking one, you can play this to your advantage. If you're defending one, you got to be very careful of it. The attention span is shorter when it's a remote deposition or a remote trial. So I will leave it to you, whichever side of the V you're on, as to whether you use that as a positive or a negative. But the construct still holds for either of you. Cheating and coaching. I'll touch on this again at the end. It's a real problem. People think they're being cute, right? What I say on the slide is a particular concern is coaching of the witness. And so you ask the witness under oath during the admonitions whether there are any other persons present in the room. Anyone else in the room? I don't want anybody else in the room. If I'm taking it, I want them by themselves. If I'm defending it, golly gee, I don't know. But if the person taking it says other people are excluded, then they're excluded, right? It's just leveling the playing field. And I also ask under oath, have they been or do they have the ability to communicate electronically with anyone, their lawyer or anyone? Because I hear stories of witnesses texting their lawyer or texting other witnesses or texting colleagues or using some kind of chat thing. Well, you know, when I was a kid, we called that cheating, right? So you want them to state under oath that they won't do that. You want to bind them to that. I highly recommend that strategy to you. So the next challenge that I'll point to is service delays and interruptions, and these will occur absolutely under the best of circumstances. But Two things. First of all, to have a really competent, effective deposition, or by the way, trial. I know this presentation focuses on depositions. I've done trials remotely, okay? And you have to expect the unexpected. You have to know that these things will happen. It's just the nature of the beast. It's like a train. Sometimes the train has to stop. Oh well, could be the best train in the world. Same thing with a trial or a deposition testimony taken remotely. You have to expect it, okay? And what I would recommend is be as patient as possible and be kind, all right? It will go over a lot better with the jury, with the judge, with the magistrate, with the referee, with the ALJ, or whomever else is involved. If you roll with the punches, work with the technology, and be gentle and kind. I just recommend that to you. And don't place blame and approbation on somebody. It's not a good look, and you'll do your client better. So the next thing that I would present in terms of challenges of the video deposition, also trial, is the absence of visual clues. So when you're in person, your witness, if you're defending, or your opposing witness, if you're taking, they can read your face pretty well, and they understand visual clues. It's harder when it's remote, right? And so there are strategies to mitigate against some of this. What I will generally do, and I'll share my secrets, when I'm preparing a witness, I will tell the witness that she or he should listen to my objections, and I won't make objections over minor form things. Just don't do that. So if I make an objection, it's worth listening. If it calls for speculation, you might politely think to yourself, am I speculating? If it lacks foundation, same thing. Or if I object that something is vague, they might think, is the question vague? What I will also suggest, giving up my playbook here, is the more vociferously, strongly, that I object to something as a signal to the witness that she or he should take it more seriously than an ordinary objection. Because I don't do it just for the sake of being annoying. If there's a certain iron in my voice, it's there for a purpose. And, you know, for whatever you're paying for this video, I have no doubt it'll be played back in court someday. But in any event, you got the benefit of it today. So the next topic is remembering to take breaks. So this is actually important, and I've fallen victim into this trap during remote depositions because we're all used to 2-hour Zoom calls with no breaks. They go on interminably, and we're all checking our Gmail on a separate iPad, or God knows what we're doing. But the breaks are actually even more important during video depositions because we're used to sitting down and trying to get things over with, and it gets sloppy. And so whatever your usual break time is during a deposition, I would confine it to that. For me, it's about an hour. So one of the other special challenges that video depositions or video trials pose is, of course, technology and unfamiliar technology, right? And so one of the things you'll face is if you have 3, 5, 10, 20 participants in a video deposition or a video trial, all it takes is one of them to screw it all up. And people have various technological skills. I will confess that my own chief technology officer is a 16-year-old daughter who knows far more about this stuff than I do. The trick of it is, if you're going to get the best testimony, if you're going to get the best record, which I assume is what you want, whether you're on either side of the V, right? Whether you're defending or prosecuting, you want the best record you can get. And so at a minimum, you should conduct absolutely a test run of the technology if you're defending with your witness, if you're taking with your parties, right? And you should ensure that the other side has done the same. It's crucially important, and it makes the proceedings go a lot smoother, and it avoids a lot of acrimony, and it will get you a cleaner transcript and a cleaner record. And so, particularly if you haven't done it a ton of times before, or if anybody hasn't done it quite a bit before, I'd advise you preview it and invite people to try it. And the court reporting service, God bless them, will be more than happy to share with you how to do that. And you should approach them for that. And I won't talk about cost. They really should offer it for free, in my opinion. And then, so the next bullet point on the slide is to check the device and the connection that you have on the day of the deposition and try to work out and work through all the features. Learning as you go is not a good way to do a deposition. Just like learning how to fly a plane is not a good idea when you're trying to fly it. You might as well know in advance and learn how all the features work. Very important. You have to understand the dashboard that's in front of you. You have to understand the controls. Because otherwise, it puts you, whether taking or defending, at a substantial disadvantage if you don't do that. So I would encourage that. Now, there are people who have said that you should have another lawyer with you or a litigation staffer with you or that sort of thing to help you with those things. Well, that's fine. You know, if the costs will bear it, if you have such a person, wonderful, go for it. Whatever you need, you might as well have them present so that you can be in control, whether you're taking or defending. You want to be in control of the situation. And if you're fumbling around, it's just not a good look. I don't recommend it. The silly things, time zones. One person's on Mountain Time, one's on Central Time, one's on Pacific Time. It'd be really neat if everybody knew when the deposition actually was going to occur, right? So you want to clarify that stuff. So in the notices I send, I make sure that I send clarification. We're going to take this at 10 a.m. Pacific, 11 a.m. Mountain, 2 p.m. 12 noon Central, whatever it is. So there's no ambiguity, so that we don't have to mess around with that kind of thing. And you want to send this information out well in advance of the deposition. There's nothing more annoying than when this stuff has to be requested. Well, there are things more annoying, but one thing that's very annoying, I should say, is when you have to request this information 10 minutes before the deposition. It should be done in advance. It's kind of a courtesy. So now we come on to relating out of that topic, the witness, okay? Technology and the witness. And it'll say on the slide behind me, a witness who becomes frustrated or fumbles with the technology will not be a compelling witness. True. but worse, will be insecure. If it's your witness, you got to put yourself in their shoes. It's not fun to be a deposition witness. I don't enjoy it as a lawyer, and I've been there. I can only imagine what it's like for a layperson. They're scared, they're nervous, they're worried, they want to do the best they can. And then all of a sudden, in addition to all of that, you give them a microwave they don't know how to work. It doesn't do you any favors. You got to make sure, if it's your witness, that they are familiar with the technology and comfortable with it, right? And it says on the slide, it's not realistic to expect that a witness will be technologically adept. It's not. You have to walk them through it, okay? Because it's hard enough for them as it is. And you don't want to introduce an unnecessary problem. So that's a special challenge that comes with the remote deposition or trial testimony. It's an inverse gift with purchase, right? So you want to take the fear out of it. One way that I've done it is to do the witness preparation on the same platform and technology as the deposition will be. You're going to have to prepare them anyway. You can do it in person if you like. Nothing wrong with that. I've always enjoyed in-person preparation. But if you do it on the same platform, then the platform is familiar to them. And so it takes a little bit of the nervousness out of it, if that makes any sense. And then at the bottom of the slide, it'll say, if the witness fumbles with the technology, they'll get insecure and they'll fumble with their testimony. And they may even forget parts of their preparation. So as the lawyer who's representing the witness, you want to make sure that they're as comfortable as they can be with the technology, because the testimony is what matters. The technology is just what'll screw them up. So I offer that for your consideration. We have a slide now on connectivity. I'm not going to read it to you. It'll be, well, I'll read it to you. Broadband or wireless internet connection, 3G, 4G, 5G preferred, good audio speakers, speakerphone, web camera, etc. You want to make sure they have the right stuff, okay? You don't want them trying, God forbid, to be appearing at a deposition off their iPhone in a car in the playground of their daughter's nursery school. And having done that myself, I would recommend that it's to be avoided. So you want to make sure they have the appropriate technology. Everybody has to have the appropriate technology. So more special considerations to lean to. The next headnote you'll see is complex questions are even more confusing. So complex questions are to be avoided generally at trial. And when I take a deposition, I try to keep the questions very simple. One of the best series of questions you can ask is, why did you do that? Or, what happened next? Or, what were you thinking at the time? Very clear, direct questions. So those are always recommended as a general tactic. With video and remote depositions, a complex question becomes even more complex because for some psychological reason that I can't identify, it's harder to track the question when it's being delivered on a screen than when it's being delivered in person. So this is something you have to overcome. And if you're taking the deposition, you should be very clearly focused on short, direct, admissible questions. And when you're defending the deposition, you should train your witness to only answer short, direct, admissible questions. And the witness is entitled to a clear question, whether you're taking or defending. You have to keep in mind, for purposes of our present discussion, that when you're doing it remotely, it's harder to track the questions. So please keep that in mind, whether you're taking or defending. The next head note that I have is titled Making a Connection with the Witness, right? And taking or defending, you'll have different goals in this regard. Humans tend to make connections. It's kind of baked into us. We try to be helpful, okay? We try to identify with people, and we try to get to the point. It's harder when it's done remotely, okay? So if you're taking the deposition, strategies vary, and I think the slide says no matter what kind of relationship is desired. Different depositions, different cases, different witnesses have different approaches, right? Sometimes you want to come across as friendly, decent, respectful. There are some people who wish to be terrorists. I leave that to them. I won't name any names. It's highly situational. But the point of the matter is, when it's being done via video, it's not as significant as when it's being done in person. It doesn't come across that way. So it's tougher to establish the connection. So I offer that to you. The next topic I have is video, audio, and written recording. You know, it's funny. When you take a video deposition, you would assume it's being recorded. No. You need to work that out with the court reporting agency in advance, and they will charge you for it in all likelihood. And you have to look at your deposition notice to say that it will be recorded. Or maybe if you're defending, you don't want it to be recorded. I've defended a few in the past week. I didn't care at all if it was recorded. Fine by me. But you want to get it in, if you want it, you want to get it in the notice. It has to be in the notice in most jurisdictions. And you want to make it clear to the reporting service that that is your desire. Because do not assume for a second that just because you're on video, there will be a permanent record. So I offer that to you. Now, exhibits. This is where it gets a little bit tricky, because we've all taken and defended depositions, and we usually hand the exhibits across the table and slide them across the conference table. Madam Reporter, would you please mark this as Exhibit 1? Okay, pretty easy. And if you're really slick, you'll have her mark up a bunch of stickers so you can mark the originals. Can't do that remotely, okay? So what do we do with the written exhibits in a deposition that's taken via video conference? Yeah, I've studied this. I've dealt with it a bunch of times. A lot of these choices, and I'm going to give you 5 of them, a lot of these choices will come down to how cooperative you are, how big the exhibits are, how well you get along with opposing counsel, how much pain do you wish to bear, right? And so those are basically the considerations. But the 5 options that I've learned and explore are as follows. Pre-mark, first one, point 1. Pre-mark and share the exhibits prior to the deposition. PDF them to the other side and to the witness. They can look at them in advance, and then you know what it's going to be. You don't have to mark them, but at least you have a hard stack of documents that everybody has in front of them. And then you can use what you want, identify what you want, mark what you want, and the rest goes in the blue pail, the recycling bin, right? Disadvantages, as a slide will note, is that it becomes a problem with impeachment exhibits that you don't wish the other side to see. There are ways to deal with that are subsequent 4 topics we'll talk about. But that is a bit of a conundrum. And the other problem, of course, is it lets all parties know what the potential exhibits are. So, I've had people who are sweet enough to send the exhibits over 15 minutes earlier, and I'll take a quick whip through them, often with the witness, or if I can cajole them out the night before, I'll do that, and I'll see if there's anything lurking in there. But, people are entitled, counsel are entitled to withhold impeachment evidence, even at trial, right? So you have to disclose your exhibits at trial in almost every jurisdiction I've tried a case in. But you don't have to disclose impeachment evidence. You can keep it wrapped up. And of course, admissibility of impeachment evidence, we could have a whole class on. It has to be directly responsive and rebuttal to a fact proffered, essentially. But, so those are the advantages and disadvantages. You send the exhibits over. If it's a who shot who case, who cares? The loan contract, the promissory note, the boundaries of the title policy, whatever, who cares? But if there's real smoking gun stuff, you want to think about that option. So again, just to reframe it, pre-mark and share the exhibits in advance. Okay. Option 2, use the screen share function. So most software will allow you to put screenshots on the computer. And then you can give the exhibits to the court reporter afterwards, right? And so you can just put them up on the screen and ask them to review them. The trouble with that is, in my experience, when I'm defending a case, I am somewhat a stickler for the concept that you don't put up a single page of a 27-page document and ask the witness to tell you what it means. I'd like the witness to see the whole document. Seems kind of fair. If you're telling me he signed it or she signed it, it'd be nice to know what it is. And let them take a little bit of time to familiarize themselves with it. Well, when you do that with scroll share, then you find yourself paging up and down that hypothetical 27-page document. And it's very hard to know what she or he is or is not reviewing at any given time. So it's cumbersome. And there may be objections as to the testimony that results therefrom. I could certainly think of several, and I'm sure you could as well. So screen share is an option. Single-page document. I mean, look, if it's a claim check for a valet parking or whatever, fine, that's great. It's one page, whatever. But if it's a complex business transaction, gee, I'm not sure that's going to work out that well. Option 3, use the case's entire file of produced documents. Well, there's something to be recommended there. We've got documents 1 through 10,000. They're over there in boxes. Mr. Witness, would you please pull out document 657? That can work. That can work fine. Depending on the size of the file, right? I mean, if it's just a few boxes, that should be fine. That doesn't solve your problem of the consumption of time that's involved if they have to rustle around looking for the documents. And it doesn't solve the problem of what about your impeachment documents that likely may not have been produced. So it's an option, and it could work very well in the right kind of case. Exhibit sharing software, option 4. There are a number of vendors who sell very fine products, and I'm not going to endorse any of them, but they're easy to find, and they give you the idea of how to share separately from the video transcription from the Zoom or the WebEx or the whatever the other vendors are. The ability to share documents. Everybody has their own private file, and the documents reside therein until they're shared. And so, that is something else that you can consider. I've never done that myself. I instead, in a larger case, go to option 5, which is use the court reporting company's exhibit sharing platform. And we say here that many larger firms offer specialized exhibit sharing software that allows you to upload, mark, and share exhibits. And it works very similarly to the private exhibit sharing software that you could purchase on your own. One of the nice things is that the court reporting firm owns the process. One of the less nice things is that you have to pay for it. But, in terms of client cost, you got to weigh it against what you're going to charge for your own paralegal. You do what's best for the client, right? My personal view is if you use the court reporter service, they kind of own the process. And if something gets screwed up, you got somebody to talk to. It's just one person's view. And it also makes the exhibits in the record a lot easier. One of the most important things after knowing the rules, and I would really emphasize knowing the rules, because without the rules you have nothing. But once you have the rules down, then we come to the portion that I talk about setting the stage and witness behavior, okay? And this is critically important. It takes me back to a case many years ago where there was a bank teller in a bank robbery in Los Angeles. And a young United States attorney, deputy United States attorney, assistant, I should say, AUSA, suggested when he was preparing her, she said, what should I wear to court? And he said, well, wear whatever you would normally wear to work. Well, unfortunately, her testimony was on Halloween, and so she dressed as a cat because that's what she would have ordinarily worn to work on Halloween. Not so good in federal court. So encourage your witness to dress professionally, because even though they may be sitting in the comfort of their own home or in some lawyer's office, they may be played on a screen in front of a jury. And if they're lounging sloppily in sweatpants, it does not make a good impression. It just doesn't. They're representing either themselves or more likely the company, and they owe it to themselves or to the company, or both, to present themselves professionally. I have done video appellate arguments where counsel has shown up without a tie. I can't quite get my head wrapped around that. They need to dress like they're in court. And so the first bullet point will say, ensure a neutral, non-distracting, inoffensive background. That's really important, because if you're actually going to try the case, you want to know that there's nothing offensive in the background, right? And jurors get offended by different things, okay? Some people may love Nantucket. Some people may love other things. I don't know. But if you don't have any of that, then you're not going to offend anyone, all right? But I would say, and the next bullet point will tell you, don't use those fake backgrounds from Zoom or wherever. First of all, they're fake, which tends to undermine the veracity of the witness's testimony. In other words, tends to make them look phony. Second of all, when they move their head around, the background shifts, it makes their face fuzzy. It's just not a good thing. Not a good thing. Lighting, hugely important, right? You don't want them to look like they're Gollum in a cave out of Tolkien, right? You don't want them to be some hunched-in little figure hiding under a rock. So you want to see the setup. And this goes towards what I was speaking to earlier about using the same platform for their preparation. So as I'm often told by my closest friends, pick your head up, stand up straight. Well, it's good advice. It's good advice, and I should do it. It's absolutely right. And you should instruct your clients in the same way. Now, at the bottom of this slide, Zoom has a feature that says, touch up my appearance. Now, I've never used it, but it's recommended by a lot of people. Supposedly, what they say is it can smooth out your skin tone and present a more polished looking appearance. It's actually fascinating from an ethics standpoint as to whether that's actually an alteration of the testimony. I leave it to you. I've seen this recommended. I've never used it. If somebody would polish up my appearance, I would be eternally grateful. All right. So, next bullet point. Closed room, no noise, no dogs, no phones, no nothing. Right? You're testifying in court. Okay? Your poodle does not join you in court. Nor does your toddler. Nor does the gardener's leaf blower. None of that. No. It's not how we do it. If you have to have the witness do it from her car, that's fine, as long as she's not driving it. But no distractions. It's a serious proceeding, okay? Another reason to prepare when you are pre-depo, right? When you're doing the depo prep, if you're defending. If you're taking, by the way, the counter strategies are obvious. If the defending person is stupid enough to let his witness look like Gollum in a cave, hunched down with eyes down, well, run with it. Enjoy yourself. But the best camera angle for a deposition is eyes on, straight on. It's the most sincere. It's the most compelling. You look straight into the lens. Now, if I had a laptop in front of me instead of a professional camera, well, the laptop would be down here. So what do? Well, in the old days, I'd say telephone books, but they don't exist anymore. So I would grab a couple of regular books, and I'd put them underneath the laptop. So it was eyes up, level straight. Right? People believe people who look them in the eye. People distrust people who look away. It's just how life works. And the other thing, the next bullet point I'll tell you is via video, eye contact is even more important than it is in person. Because in person, you can read body language. Like I'm sitting here with my hands pursed together, tapping them for emphasis. Well, I don't think you can see that. Maybe you can. I don't think you can. But it makes me more convincing in person. On video, all you have is the person's face and the eyes. So the eye contact and the sincerity of that is even more important. The last thing I'll leave you with is that, some lawyers are dirty birdies. They just are. And they try to find trickery wherever they can find it, right? Some people play the edges of the field. It's unfortunate, but they do it. Video depositions lend themselves to a little bit of trickery. And so at the last slide here, I present the fact that video depositions lend themselves to trickery and special admonitions are appropriate. So in addition to all the admonitions in the beginning of the deposition, which you would ordinarily do, I include the fact that you should admonish the deponent that no notes are allowed during the deposition. In fact, what I do is I ask them if they have any notes in front of them, and then I ask them to be sent right over to me. But in the admonitions, I'll say the deponent shouldn't read anything other than the exhibits presented by counsel. I ask them to state under oath that their desk is cleared, that they have no secondary laptop or desktop or tablet or iPhone in the room with them that they'll refer to. And I should also ask them if there's anybody else present in the room. And I will ask that they are either excluded or that they are also videotaped, right? So that's what I offer you. I will say this on a most positive note. Remote depositions will save the clients a lot of money. They are workable in all but perhaps 1 or 2% of cases of such significant importance that you just feel you have to do it in person. It saves the clients money. I, pre-COVID, would fly 200,000 miles a year, most of it within the U.S., and a lot of it for trials and depositions. That's a lot of wear and tear, and I'm pretty familiar with Dallas-Fort Worth Airport. So we need to find the best ways and practices to do this, and I think we're working on that, and this may turn out to be a great gift to the profession and to all of us. So I hope you gained something from this, and you're more than welcome to email me at any time, and astruve@buckhalter.com. And thank you for your time and attention.